Thank you for joining us. This is the webinar on Act 133 and what realtors should know. My name is Pete Kennedy. I am the Communications Manager for the Suburban Realtors Alliance. If you're not familiar with the SRA, we are a government affairs office, and we work for the members of our two shareholder associations, the Bucks County Association of Realtors and Tri-County Suburban Realtors. The SRA works at all levels of government, the federal, the state, the county, and especially the local. Our topic today, Act 133, is a state law that sets rules for how local municipalities can operate regarding private property transactions. So we're going to talk a bit about the law, what it says, how it has actually affected realtors and their clients since it was enacted a few years ago. And we're certainly going to try to explain what realtors should know to make sure that they benefit from the protections of Act 133. I'd like to welcome our two panelists. Jamie Ridge is President and CEO of the Suburban Realtors Alliance. He is my boss. Jamie has been working for years to help realtors navigate the municipal use and occupancy issues in the Philadelphia suburbs. He was also part of the team that helped get Act 133 passed in the first place. Hello, Jamie.
Hey, Pete, thanks.
Thank you.
Looking forward to it.
We're also joined by Hank Lerner. He's General Counsel at the Pennsylvania Association of Realtors. In that role, he works on all kinds of legal issues from across the Commonwealth, including those stemming from Act 133. He oversees the standard forms and the professional standards programs there. His is one of the voices that you might hear if you call into the PAR legal hotline. And he also was a key part of the PAR team that helped get Act 133 passed in the first place. So welcome, Hank.
Great, thanks. Happy to be here.
Great to have you. If you have any questions for our panelists, you can submit them through Zoom's Q&A function. We'll try to get to some of them as we go and at the end. I also would encourage you to, after the webinar, check out the SRA website at suburbanrealtorsalliance.com. We have an Act 133 information page there, which has a lot of the key information, but also links to other resources. And we have our municipal database that has details of U&O inspection processes for each municipality in the Philadelphia suburbs, and there's 238 of them. So a very useful tool. If you haven't checked that out in the past, please do so. One quick point of clarity before we turn it over to the panelists. Act 133 is sometimes known as the Municipal Code and Ordinance Compliance Act, or MCOCA. MCOCA was passed in 2000 as a state law, and in 2016, Act 133 amended that law in some important ways, and that's what we're here to discuss. So for the purposes of this discussion, Act 133 and MCOCA are pretty much interchangeable terms because they refer to the same law. So Jamie, on that note, can you get us started and give us kind of a general idea of what Act 133 is and does?
Sure. Thanks, Pete. So Act 133 creates a statewide uniform process for the issuance of resale, use, and occupancy certificates. Importantly, it requires that once a municipality has conducted a use and occupancy inspection, one of three certificates must be issued, depending on the code issues that are found. Each of the certificates allows settlement to move forward, and that's an important piece of this. The certificates are, number one, a clear use and occupancy permit, meaning that no code violations were found. Number two, a temporary use and occupancy certificate, meaning that code issues were found, but they do not make the home unfit for habitation. And then number three, a temporary access permit. The temporary access permit, which was added in 2016 with the amendment, is issued when a substantial violation is found that makes the home unfit for habitation. Importantly, a temporary access permit allows the home to be sold, but it does not allow the home to be occupied until the substantial violations are corrected. So under both of the temporary permits, buyers have 12 months from the settlement date to make the repairs. That timeline cannot be shortened by a municipality. It can be extended if a municipality agrees to granting more time for the repairs, but not shortened. So along with the temporary access permit, the amendment added a definition of unfit for habitation. And there was no definition of unfit for habitation under the original law that was passed in 1999. So this was also important. And then finally, Act 133 banned municipalities from requiring escrow as a condition of receiving a temporary use and occupancy permit.
I see. And so Jamie, why did the old law need to be amended? What was the situation before Act 133 was passed?
So Pete, the main reason for the 2016 amendment was because some municipalities were abusing several loopholes in the original law. With no definition of substantial violation, municipalities were claiming that very minor issues like a cracked sidewalk made the home unfit for habitation. Because the borough or township was claiming that a home was unfit for habitation with no definition, they were allowed under the old law to withhold a temporary U&O until the seller made all of the repairs. That stripped away the ability of sellers to negotiate the repairs with buyers. And it even led to a few foreclosures when sellers didn't have the money to make the repairs prior to settlement. This was happening especially when we were having a lot of short sales after the last recession, and foreclosures were at a very high level. Number two, the escrow issue was also a big problem for some buyers. We had municipalities in our area requiring up to $5,000 in escrow to be held for sidewalk repairs, for example. That was sometimes a deal breaker, especially for first-time home buyers who didn't have an extra $5,000 laying around prior to settlement. So those were the main reasons for the amendment.
So Hank, does it seem like the amendment, that these revisions did the trick? I mean, are you still hearing from members who are experiencing U&O issues?
Yeah, so when you ask if it did the trick, I would say yes and no, or I might even use the phrase, it depends. So congratulations to whichever one of you on the line, had 8 minutes in the pool to figure out how long it was going to be until I used that phrase. There are definitely many municipalities who have become fully aware of this law and are aware of the changes and are aware of what they're supposed to do. And if they are aware of all that and they've made the appropriate local changes, then yes, this is great. It's pretty much doing what it's meant to do, as Jamie said, giving the flexibility to the buyer and seller to negotiate what they need to do, not dumping all of this on the seller at the very last moment as they're trying to close a deal, but allowing it to be, negotiated out between the two parties is huge. So in many, and I would guess most, although Jamie would have a better feel for that, many or most municipalities, yes, this is great. It's being implemented and it's moving forward. However, of course, that only works when the municipalities actually do what they're supposed to. So are there members who are having trouble getting U&O permits? Absolutely. Generally in municipalities that have just not fully implemented this the way they're supposed to. And legitimately in some instances where there's let's say an interpretive difference between the parties and the municipality. But there are just some who haven't quite gotten to where they need to be in terms of implementation.
Okay, thank you for the information and for the $10 I just won in the legal lingo pool. So why is it taking these municipalities so long, or some of them, to implement that, to make Act 133 part of their ordinances and their procedures? Shouldn't it have been done? I mean, it's a state law. Shouldn't it have been implemented immediately when it took effect in January 2017?
Yes, but we all want things, like we all want municipalities to do stuff immediately. My daughter wants a pony. So, everybody wants things, but we can't always get what we want. Why is it taking them a while? I can give you a couple of different reasons. One is, I think, inertia. Municipalities like realtors, like realtor associations, just kind of run on the way we've always done things. And if there's a set of rules and policies in place, sometimes they just keep doing them until somebody actually raises their hand and says, hey, buddy, you need to change this. So I'm sure that some of it was simply ignorance, which I say in like the good kind of ignorance. The law passed, they just didn't know. So they kept doing what they were doing. There's another kind of inertia there, though, that I think may have also been in play in some cases, which is the inertia to say that they knew what they were doing was wrong. They knew what they were doing was already wrong. Right? As Jamie mentioned, the old law was being abused, which was the whole point here. Some of them were fully aware that they were abusing the old law, and they just use that inertia to say, well, nobody stopped us before. So we know what we ought to be doing, but we got away with it before under the old law. So we're just going to keep doing it until somebody stops us. So kind of the same idea. Let's just keep moving on until we get some pressure on the side of the boat here, but maybe more deliberately than in other areas. And then I think there's a third, which is that at least in a small number of municipalities, there was a certain amount of purposeful defiance. So we don't care what the law says. We don't want to do that. We don't think that is right for our municipality. We don't believe that that's what the law ought to be. So we're just going to keep doing what we're doing, or possibly even change it to make it worse. And we're just going to dare you to come after us and do something about it. But we're just going to keep moving because we believe this is what's best for us, regardless of what the state law says. Now, that maybe isn't the best approach for some people. Because occasionally somebody comes along and actually puts the pressure on the side of the boat and says you would need to knock that off, which coincidentally enough segues into the next part of the answer, which is to reference Glenolden Borough. So that was one of the municipalities that SRA deals with that was, I guess, particularly egregious in how they were treating this stuff. So a few years ago, PAR and SRA teamed up together along with a local property owner to, let's just say, move the conversations out of the council chambers and into a courtroom to say, look, we know that you're doing it wrong. We're pretty sure you know you're doing it wrong. But if you're not going to change it, then we are willing to come in and do something about it. And if you just want to think about it, just simply like a playground bully, right? Like if somebody takes your lunch money 3 days in a row, they're going to keep taking your lunch money until somebody does something about it. You don't have to, pick a fight on the playground. Sometimes it's just telling the teacher, and the teacher comes by and implements the rules and says, you can't do that anymore. So we got involved with a lawsuit against Glenolden Borough on behalf of this property owner. The details of the lawsuit are mind-numbingly boring and nobody cares. So we'll just skip over them and we'll get to the results. And the results were that Glenolden basically admitted that they were wrong and that they needed to change their ordinance. So they did. They changed the local ordinances and took care of it so that it now says what it needs to say. I think probably the more important part was that they also set up sort of an ombudsman process locally. Sometimes one of the most frustrating things, and you guys all know this way better than I, the most frustrating thing in a municipality is sometimes actually finding the right person to talk to. Like, is there someone who will answer their phone or their emails? And if so, is it the right person to actually get the conclusion that you need? So they set up this sort of an ombudsman process so that if Realtors or if SRA says there's a problem here, they actually have a person to go to who is supposed to be taking those calls and working through the issues. And as an added bonus, because PAR did fund this process, there was a certain amount of money that was paid back in terms of legal fees. So we did have some skin in the game. We did spend money on this case, but also Glenolden paid back some of that money in the way in terms of legal fees. So that was something that we felt really strongly about at the PAR level. This was a law that we worked to pass, something SRA brought to us specifically. We put a lot of capital into it, and we were not going to pass the law and then just wash our hands, put out the press release, and walk away. So we really felt that it was necessary to sort of make an example if it became necessary, and it did. So that's what we did with Glenolden. The interesting part of that, going back to the bully scenario, is that sometimes when one bully on the playground gets shut down, other bullies start paying attention. So I will toss this back to Jamie, because I believe that the Glenolden case may have also helped more globally in the marketplace beyond just that particular municipality.
That's a great point, Hank, because there were a lot of bullies watching the proceedings for this federal court action, and they saw what the result was, and many of them stopped what they were doing, immediately. I wish I could say 100% they've stopped doing this across the board, but we still do have some outliers that might claim, oh, we weren't aware of it, or as you said earlier, we're just going to keep doing it until somebody makes us stop. And we do have a couple of those municipalities left, especially in Delaware County, and we're watching them very, very closely. But the ripple effect of that Glenolden action was big, and it was across really our entire region, and it gave us something to share with municipalities when they were kind of on the fence as to whether or not they wanted to follow the new law. So it was extremely powerful and useful for us. It still is.
I want to take a quick moment just to remind folks that they can submit questions to the Q&A tool if they have anything that they want to ask the panelists. Getting back to the law itself, Hank, are you seeing situations in which a municipality can still withhold permits even with Act 133 in place?
Yeah, so one of the things about Act 133 is that it was really specifically targeted. So when we wrote the words, we were looking at a really specific use case, which was municipal codes, municipal ordinances, municipal inspections. Like anything else legislatively, when you draft something, inevitably another use case pops up, or there's a what if that maybe hadn't been thought about, or a new situation arises. So it's important to understand that this does only cover municipal ordinances, municipal code issues. Excuse me, I get so choked up when I talk about this topic. So there can be inspection-related issues where MCOCA simply doesn't apply. One of the most clearly obvious, but it comes in the category of we have to say it out loud just because there's somebody occasionally who gets confused, is that there are lots of inspections that have nothing to do with permits in MCOCA. So you might have, for example, a lender who says, I need to have an inspection done of the roof and the chimney liner before I'm willing to sell you the house, or before I'm willing to finance the house. And if you don't get the chimney relined, I'm not going to write the mortgage. And then somebody gets into the process, they can't get the loan, and they go crazy because there was an inspection and they're supposed to be able to move in. So they just kind of confuse the issues. So it's not a municipal inspection. It's not covered by this law at all. But somebody just sort of remembers, for example, I was on a webinar and they said, once there's an inspection, I have to be able to move in. So there are certain people who just get a little bit twisted around when they call in, and we can straighten that out. That's kind of the easy one. The one that gets harder is this gray area stuff where there may be things that are implemented at the local level, but they're really not municipal codes or municipal ordinances, or they might be, but they're only at the municipal level because somebody higher than them makes them do it. So for example, in some areas there are like regional sewer or regional water authorities. So if the regional sewer authority says, as a condition of being part of this authority, we need the following stuff to be done at point of sale, and then a municipality implements an ordinance to make it happen, it is a local ordinance, but it's a local ordinance that they didn't just adopt voluntarily on their own. They adopted it because the regional organization said, you need to do this. So that's a gray area. That is one of those things where it was not really the intent of the amendments to kind of get at that. And that's the type of thing that is happening more and more. There are, additional municipal water and sewer authorities out there. They're having to implement new rules. Those rules are kind of filtering down to the municipal level. So some of those may not actually be covered by this law. I'm being intentionally vague here if you haven't figured this out, because we don't have a specific policy determination or interpretation. And in fact, it could be different based on the specific structure of that municipality and how the ordinances are implemented. So that's one of those areas where it's a little bit iffy. And related to that, for example, the DEP, Department of Environmental Protection, has been pretty aggressive with stormwater management issues recently. Same thing. Some municipalities are adopting ordinances for stormwater management, but they're doing it because the DEP has told them they have to, or because they've entered into a settlement that agrees to do it. And it would be difficult to say that DEP told you that you had to do this, but somehow the permit law just kind of overrides that. So again, it's a little bit iffy because we think sometimes the ordinances are not actually required. So there may be a little bit of a difference there. So if there's an area where you're not sure, then ask the question. Like, don't go in guns a-blazing and say you're wrong, you're wrong, you're wrong. That's why you have resources out there. So call the PA or legal hotline. We can help you understand that. Call SRA. They can help identify, particularly if they've dealt with this before in a particular area, they may already have an answer. I've already talked to fill in the blank, and this is what we've worked out. So ask the question. It's great to be informed and knowledgeable, but you don't want to go off until you're absolutely sure that a particular situation is covered by the law.
I would say that I've just recently learned that there is an effort at the state level to look at Act 133, one of the gray areas is around these municipally owned authorities. And the question is, when an authority requires an inspection of an easement or a sewer lateral, do they fall under the same, Act 133 rules? And that is a gray area. And so there's an effort, there's a state legislator who's trying to clarify that. We are working with that legislator to get some language to make it more clear that yes, these entities, this does apply to them as well when they're related to municipalities. So that's something that we're going to be working on through this current session.
Okay, and Hank, if a realtor is not sure whether a municipality is following Act 133 or suspects that they might not be. So, as you said, they can call the SRA, they can call PAR's legal hotline. What else might they do in terms of before they make that call? Is there any information they should gather?
Yeah, so I do this a lot on the legal hotline. So it's nice to be able to do this on video because there's a visual that you have to imagine when I give this answer on the legal hotline. I am a huge believer in what I call the stupid face. The stupid face is the face that you make when you go to somebody who has an answer that you want, and you just ask them innocently, hey, could you help me out with that? So for example, oh, you can't give a permit. I thought you had to. Would you mind showing me the ordinance that says that? Because I'm a little bit unclear. So, I would start with the stupid face and don't go in telling them that they're wrong. Don't go in telling them that you know more than they do, but go in first by saying, give me the proof. Show me the ordinance that says you're allowed to withhold the permit. Honest to God, sometimes they give you something that says exactly what's in the law. And then you can say, well, but it says here, you're supposed to give me a permit. Stupid face again. I don't understand. Why didn't you give me a permit? It says here you're supposed to. So sometimes just kind of having those conversations kind of backs them into a little bit of a corner because they are forced to engage in the conversation and either admit that they're doing it wrong. Well, that's not really how we do it. Never mind. Or they might give you an ordinance that is wrong, in which case you can go say right back to SRA and say, well, look, we talked about places that are doing it wrong. Here it says that they're not going to give me a permit if, and now that makes it a whole lot easier for somebody like Jamie to go back and have the conversation because it's not just a hypothetical. We actually have it in writing that you're doing it wrong. And again, with the municipalities, this is terrible because you could talk to the codes enforcer who says one thing and the township secretary who says another thing. If you can get them to nail it down and putting in writing, it helps have those conversations. So that's where I always like to start. And then, like I said, the next steps would be take what you got out of that, contact the PAR legal hotline and or SRA. I will tell you, we do have a habit of ping-ponging people back and forth based on the circumstances. So we can explain maybe the law in a little bit more detail. Obviously, the implementation, if it's something in the SRA's coverage, is going to be for SRA to handle. I know you said you may have some people outside the SRA sort of territory. Just insert local GAD or local PAR field rep in place of SRA when I say that, because the actual implementation will happen on the ground. The PAR attorneys are not going to call fill in the blank township and tell them they're doing it wrong. That's going to be up for your local association, said the SRA field rep, et cetera, to handle that way.
Gotcha. Okay. So to put Act 133 into like the current, modern day context, because it's a very hot market right now. It's a seller's market. So Jamie, in this fast-paced market, what are you seeing with regard to the pace of municipal inspections compared to the expectations of buyers and sellers?
So we are in a very hot market right now, not just our area, but all over the state. And in our area, we're seeing settlements move very quickly. And the issue becomes, we have a municipality that says we need 30 days. Norristown is one example. Falls Township is another example. We have others. They say we need 30 days to do the process. They mean 30 days. And so if you try to go to settlement, if you'd like to go to settlement in 2 weeks, it may not be possible. and it's not right. You know, I would not argue on the side of the municipalities who are taking 30 days to do these, but they do have that authority. The state act does not give them a deadline for you know, handing these permits over or inspecting in a certain time frame. And so that's another area where you just need to get these done as quickly as possible. You know, once you have a seller, you know, move forward very quickly to order that inspection if it's needed in that municipality.
Okay, and Hank, on a similar note, how are you seeing U&O processes playing out in this market? And I think it's worth noting that, you know, we're hearing about prospective buyers who are waiving their private inspections, you know, just to get an edge.
Yeah. So I want to actually circle back briefly to Jamie's comments and point out not only that you want to get inspections scheduled as quickly as you can because you want to get them scheduled as quickly as you can, but also would remind you that there is a subparagraph in the PAR agreement of sale that talks about scheduling municipal inspections. So that can be that's just reminding everybody that it's there. But also B, that could potentially be a way to goose things along. So the default, because I have it up on my other screen here, is if required by law within 30 days from execution date, but in no case later than 15 days prior to settlement, seller will order a certification, blah, blah, blah. If you know that your municipality works on different timelines, that is something that can be negotiated. Any of those time periods are in there that can be changed. So if you're saying, I know it takes them a long time, you better make that application within 10 days to make sure we have enough time to make it to settlement. That is something that you can discuss. That's why the realtors are the local experts, because you know that this municipality works differently from that municipality, and you can make the contract work for you. And speaking of contracts, you're right. There is a ton of waiver going on out there. I will, if you'll allow me, just put in a brief plug for PAR Just Listed, which is the PAR blog, where we explain things like what you're doing is probably not what you think you're doing. And please, for God's sake, stop writing things in if you don't understand them. So sometimes the waivers are good because people actually understand what they're waiving and what the circumstances and possible repercussions are. Oftentimes, however, they do not. This is one area where they clearly do not. Because buyers will say, I'm waiving inspections. Sellers will say, oh, you've waived all inspections. I believe we've had a couple of instances where somebody tries to lock out the municipal inspector because they say, well, no, buyer, you waived your inspections. Like they don't understand that's a different inspection. That is not something that the buyer gets to elect. It has to happen. Or they'll say, well, it doesn't matter. Like you waived your inspections, so you have to accept the results of whatever the inspector does. And this is my reminder that while you can waive inspections in the agreement of sale, there is a whole different provision in paragraph 15, it's 15B, that talks about if you receive notice from the municipality that repairs or improvements are required, fill in the blank. So you could waive your home inspection, you could waive your radon inspection, you could waive all of the inspections that are in paragraph 12, but if the municipality still requires a use and occupancy inspection, the seller needs to let them in. There is no ability to bar that person from the premises, or to be clear, you can bar them from the premises, but you're now in default because the agreement of sale says you will allow in municipal inspectors. And if they come back with a report, unless someone has made a change to paragraph 15 of the agreement of sale, there are rights then for the buyer to make some choices. There's some negotiation. We even have an extra form. It's form RRT that a lot of people are not aware of. This is not a forms class, so no, I will not be answering any specific questions about these later. But it's specifically a form designed to respond to municipal inspection requests where the seller maybe has already indicated they're not going to do any repairs anyway. So there's a lot of ways to address this within the contract. Everything is possible. We have it all kind of laid out for you, but you got to read the form. You have to actually understand not just how the law works and how the permit thing works, but you got to understand how the form works and how these different things play in, because I would imagine, pretty embarrassing. For example, if you're the listing agent and you explain to your client, don't worry, we never have to respond to any inspection reports. They can't make us do anything. Nobody has anything to talk to us about. and then the buyer agent, calls you over the side and points out 3 weeks later, by the way, you missed this, buddy. So just be fully aware of what's in the contract, be aware specifically of paragraph 15 and how it plays in. And the fact that buyer agent, listing agent, both need to be, again, fully aware of the result and what it means. So if the buyer in this market says, that's fine, whatever, I'll take the property, just let me close it, they could be agreeing to do $50,000 worth of repairs. So, have you talked that through? We had one the other day from somebody who was going to have to replace like a porch roof. We've also heard one in particular from somebody whose seller had to tear out a swimming pool because of the codes issues that had gone on before. And the buyer would say, yeah, that's fine, I want the property. Later on, will they come back to the buyer agent and say, you didn't fully explain to me what it meant to buy a property with a giant sucking hole in the ground and existing, permit issues. So just be super careful, lots of referrals to lawyers as necessary, and, cross your fingers and pray to whatever deity you pray to in real estate, that the transactions work themselves out.
Okay.
You didn't see that one coming, did you?
I didn't have giant sucking hole in the ground on my bingo list.
Yeah.
So I think it's a good time to turn it over to some of the questions that we received from the people in the audience. And I know that a few people on the registration form actually asked about the commercial implications. So Jamie, could you just address that quickly? What are the commercial implications of Act 133?
It's a great question. And the answer is that Act 133 does apply to commercial transactions. So if you have a commercial property, they're requiring a use and occupancy inspection. It is the same process for a commercial property. They should be issuing one of those 3 certificates, either the full U&O clear, temporary U&O, or the temporary access permit. And again, the same law that protects on the residential side protects our the sellers on the commercial side, sellers and buyers both.
Great. Hank, I have a question. Are there penalties for violations?
So there are no penalties in the law. So there's nothing in the law that says, and if the municipality does not issue the permit, they shall be fined, $5,000, or it shall be a misdemeanor or anything like that. Like a lot of civil issues, this would be enforced basically through the court system if necessary. So again, that was kind of our point with Glenolden, and I'll be really frank, between PAR and SRA, knowing that there were a number of municipalities that were kind of skating around the outside of this, we took our time trying to find a good, solid plaintiff that we felt would make a good case. The goal is to not run into court every time somebody does something wrong. But ultimately, that is going to be the issue, is that if there's a municipality that is not following the law, if it's blatant enough, if there's a big enough issue, then the remedy or the penalty is that they could find themselves on the other end of a lawsuit. Mm-hmm. And honestly, I'm not a litigator, but this is pretty clear. It's hard, although we've identified a few specific gray areas. It's going to be pretty hard for a municipality to say, we're just not giving a permit, and in any way convince a judge that that's legit. So it should be pretty clear that they need to do it. And hopefully having that Glenolden case in the bag will let them know that there is the threat of potential future litigation that they don't want to get involved with, because they're probably going to lose. And that will hopefully take care of most of the potential issues in the future.
One of the questions that came in, I think, kind of connects to that, not so much denying a permit, but are you seeing municipalities trying to shorten the 12-month time frame to get work done, such as concrete work? And correct me if I'm wrong, but I think that was actually one of the Glenolden problems, wasn't it, that they were requiring?
Yeah, we are seeing these. They're calling them the 30-day affidavit, where the buyer will sign an affidavit promising to do the repairs within 30 days. And that was one of the issues with the Glenolden transaction. He actually did sign one of those 30-day affidavits, and they fined him anyways. So that made our case even easier. But these 30-day affidavits really are counter to the state law. And the state law says that buyers have 12 months to make the repairs, period. That cannot be shortened by the municipality. I don't care if it's an affidavit or whatever. So bring those to our attention, because that's the kind of penalty. If they get penalized for waiting 31 days to do the repairs, that we would certainly look into to challenge. So yeah, that's a big one that we're seeing for sure.
We have a question. Is there a link for a website that can be shared with cities, boroughs, towns regarding Act 133? Certainly, the SRA website has an Act 133 information page, and it's suburbanrealtorsalliance.com/Act 133. And I think that would be great to share with municipalities. PAR also has a website with a lot of information about MCOCA and Act 133. But also, Jamie, I know that you are always willing to work with a realtor who to help them craft a specific approach in dealing with the municipality, right? Depending on their situation.
Absolutely. And it's really great to know what the specifics are, because we can even help craft an email, for our member going back to the municipality, to help them get that permit, and to help, the municipality understand exactly what the state law says. So we're here for you. You're our members. We provide services for you, and that's one of the important ones. That you can call us 610-981-9000, and you can have one of us call you back and walk you through this process.
Would you say that operators are standing by?
I would say operators are standing by, literally standing by. Yeah, we have a new phone system, so we're pretty quick these days.
Awesome.
And Hank, a question came in, an interesting one. Can sellers get these inspections set up prior to putting the property on the market?
Oh, I know this one. It depends, but probably not. So that's actually going to be a local municipality issue. One of the things that we've actually been talking to a lot of callers about on the PAR legal hotline is that there may be a reason why sellers would want to get a home inspection done before they put the property on the market. So there are some sellers out there who are saying, I want to get my house like self-inspected. And then maybe I can provide a copy of that disclosure form to potential buyers to deal with inspections, yada, yada, yada. So that you can do on your own, or you can not do on your own. That's totally up to the seller. It's just that's just money. Is there somebody who's available to do it, and I'll pay them. The municipal inspections, though, are different, because you have to go, as Jamie said, by whatever the municipality decides. So some municipalities may allow you to do it. If not before putting it on the market, they may let you do it once it's on the market. So, sign goes in the ground on Monday, you can schedule the inspection starting Tuesday. Others I know will not do it until 30 days before the proposed settlement or something like that, because they want the most up-to-date version of violations. They don't want violations that might have been months old. So for that, frankly, the best thing you can do is talk to your local municipality and just simply ask that question: what's the timeline for doing the inspections?
And in our municipal database, there will frequently be a notation saying that municipality requires 30 days, or they cannot be scheduled, within X number of days prior to the settlement date.
Mm-hmm.
Yeah, that becomes another one of those things where you don't want to look foolish. So like if you wait too long to get the inspection ordered and the municipality says we just can't do it, like you don't want to be the cause of the delay in settlement. So make sure that you're always fully aware of what those rules are. You can stay on top of it.
Okay. There was a question that came in about some municipalities that just are still unwilling to kind of abide by Act 133. And so, we've talked about Glenolden. Jamie, I don't know if there's any other examples that you would want to talk about maybe what approach you take, and also maybe any success stories, of places where we've been able to enact change.
Yeah, we have a lot of success stories. Don't want to brag, but I think we've done a pretty good job of, making municipalities aware of this, rolling it out. Hank and I did a whole tour, talking to township solicitors and boroughs when this was when it really rolled out in January of 2017. And I talk to a lot of solicitors still to make sure that, they understand the law, that it's actually in place. Yet we still do have some known players, municipalities, that have just refused to implement one or all parts of this. The most common is the 30-day affidavit, or saying that we don't do temporary U&Os. We don't issue temporary U&Os. And those are kind of slam dunks for us. The 30-day affidavit can be very difficult if you have a seller and a buyer who just want to move in. They don't care about the 12 months. And so they sign the affidavit and they make those repairs within 30 days. There's no way for us to enforce the 12 months with that municipality. And we do have one very large municipality in Delaware County that's still offering those, not offering, they're kind of forcing those 30-day affidavits on buyers. And for the most part, our buyers have signed the document. That doesn't give us any way to go back to say, hey, wrong, we're challenging this, we're taking you to court like we did in Glenolden. Because if there's no violation, then we can't, there's nothing for us to work with in terms of legal action. So we're watching them very closely and just kind of waiting for one buyer to be brave enough to say, I'm not going to sign that. And then we can step in.
Mm-hmm. We also had a question about properties that are already sold and the municipality did not conduct the inspection. Can they come back and inspect afterward? Hank, I'm guessing that is one of those it depends answers that really just depends on exactly how that sale went through without an inspection. Not getting any sound from you.
No, so that's because it cut out my sarcasm. I asked, do you have a law degree? Because if you don't have a law degree, you don't get to use it depends.
Sorry. No, I do not. Sorry.
All right. So just, we'll all stay in our lanes, right? God, I hope he understands that's humor. Yeah, here's the interesting thing about this whole process. If municipalities did inspections on a more regular basis, so like if they eyeballed your sidewalks every so often and said, hey, that's a bad sidewalk, you should get it fixed, then the whole point of sale thing would be less of an issue. So, don't anybody leave this call thinking SRA and PAR are, demanding weekly inspections of everybody's property for health and safety. That's not the point. But some of these things don't really need to wait until the property sells. And that is one set of rules. So if the municipality comes around at any time and sees that you have a cracked sidewalk, there's a rule, whatever your municipal ordinance says, that they can make you fix it, and there are certain requirements around it. Obviously, they differ from municipality to municipality. So if a municipality, let's say, doesn't have a U&O certificate issue, like they don't even have a point of sale inspection, and you move into the property and they come by and they see something that's bad, they can always cite you for it if they have an existing ordinance. And the replacement, the repair, whatever is handled under that normal ordinance. I would say that for the most part, if they have a U&O certificate requirement, if they were to waive it for some reason, so if they said, there's a pandemic, we aren't going to send somebody to your place, here's a certificate, move in, I don't think that they would really be able to reserve the right to do a full inspection of your property after the fact, just for fun, like they would have for a move-in. But they still always have the right to do whatever they can normally do under their regular inspection rules. So if they've got a health and safety ordinance, building code ordinance, one of the big ones I know is if you pull a permit, the inspector, like if you pull a plumbing permit, and the inspector walks into your house and there's electrical wires dangling from the ceiling, they don't have to just walk by the electrical wires. They can cite you for that too. So there's lots of reasons why an inspector might be in your house, but none of that is covered by MCOCA. So if the normal rule is electrical wires hanging out of the ceiling have to be fixed within 30 days or there's a $500 fine, I'm just making that up, obviously, then that's the rule. And you're under the regular ordinary rules. So they can't manipulate the process to just sort of wink, wink, let you move in, and then the day after, come and do a full inspection that they wouldn't normally have the right to do. But there is some level of inspection that they're able to do on a regular basis, and that's That's just the law. That would come down to it. Does it look like they're deliberately abusing the process? And if they do it once, no. But if Jamie gets 10 calls in a row from 10 transactions that all close this week and they're doing full inspections the day after, I would guess that would be the point where somebody would need to talk to that municipality about their process.
That would be a big issue.
Mhm.
The other scenario that I can think of is that somehow the municipality requires the inspection, but it was never ordered. And for whatever reason, the title company allowed the settlement to move forward without that inspection being done, without the certificate being in hand. Then the municipality can actually fine the buyer and the seller because they ignored the certificate requirement in that municipality. And we've heard of that happening, but it's very rare for that to happen because people look at the municipal database. They've worked in a municipality multiple times. They understand the process, and so they don't skip that very important step.
Mhm. Had a question come in. If a buyer feels forced to sign a 30-day affidavit because otherwise the municipality won't let the sale go through, is that enforceable? I would just, if I could just try and guess what you're going to say, it's call us first, right? Call us, the SRA or PAR, and try and get that worked out beforehand. Is that correct?
Yeah, I mean, ideally, nobody signs it because they intend to lie. So if they feel forced to sign and they know they can't get the repairs done within 30 days, yeah, ideally they wouldn't sign, or they would talk to, I mean, that might even be one where we recommend they talk to a private attorney to say, let them advise you to sign, and then how they would fight it. Like the fight doesn't have to come necessarily through us. So if the attorney is going to help you sue them, make sure you do X. So, send them a letter that says, I'm only signing under protest or whatever. But you, the agents, you're not the lawyers here. You're not the political affairs specialists. So yes, talk to other people, talk to SRA, talk to the hotline, potentially talk to their own counsel. But don't just sign it. And I know we've seen it. I'm sure Jamie's seen it as well. Don't just sign it and say, don't worry, we'll fix it later. Because once you've signed it, you have agreed to do something, and you potentially could be dinged for not doing it, even if the municipality is also wrong. So why do you want to get into that fight? Why not just try to take care of it in advance if you possibly can?
We can help you. We can help you do that in those situations.
Okay. A couple of questions have come in just about if it's being recorded, the session, and just to remind everyone that it is being recorded, and we will make that recording available through our social media, our news briefs, and our shareholder communications through BCAR and Tri-County. And I think maybe we have time for one last question, and it's a good opportunity to kind of just look at the heart of the law again. So somebody asked, when getting a conditional U&O, most municipalities won't let you move in until issues are complete. When is that violating the law? A few questions around this same type of topic. So I think maybe Jamie, if you could talk about the three types of certificates and especially the difference between the conditional U&O and the temporary access.
Sure. So the one you hope you get is the clear U&O. No violations came up during the inspection, and you get to move in, no questions asked, and you've got that. The second one is called, the temporary U&O. And that means that the municipality did find some code violations, but they were not substantial, meaning that the property is not inhabitable. The third one, and so under that second one, the temporary U&O, you can move in, the buyer can move in, and then they have 12 months, as mentioned many times, to make those repairs. Those are minor issues. The third one, the temporary access permit. This is one that came in under an amendment to the old law. This is one that we helped push through. And this means that there are substantial issues, safety issues with the property. It could be a fire hazard, electrical hazard, It could be something with the structure itself that make the home unsafe. And so then a temporary access permit is given. You cannot move into that property. You can't occupy that property until that particular situation is taken care of. The beam is fixed, the electrical box is fixed, whatever it takes to get beyond that substantial violation. I will add that if you have a temporary access permit, you are allowed to move your things into the property to make the repairs, of course. And so that can happen after the settlement date. But again, you've got 12 months to make those repairs, but you cannot move in under a temporary access permit unless that particular substantial violation is taken care of.
Okay, I think that's a good place to wrap up. I want to thank everyone who tuned in today. I hope you found the information useful. I certainly want to thank Jamie and Hank for all of their information and their time. Please feel free to email us questions, sra@suburbanrealtorsalliance.com, and to check out our website, suburbanrealtorsalliance.com. We have a lot of Act 133 information there. The recording of this webinar will be available soon. And that's about all. Thank you all so much for joining us, and have a great rest of your day.
Thanks, everyone.
Thanks. Bye-bye.